you guys on Friday went over wills. So today I'm going to be going over trust. So it's going to be very simple. And I'm going to go through just the basics. And then I found a video or two that we're going to watch to just go over the concepts as well if we have some time. But again, I hope everyone had a great weekend. We have a lot of great events coming up this week. So before we get started, I'm just going to go over it very quickly with you guys. So again, every day you should be receiving a daily email from Teresa. Bless you. And please be sure to read this email every Monday. It shows you all the events so you can plan your week out and then be able to know what you would like to attend. So today we're going to be going over trust in the morning. And of course, we have the lunch club at 12 o'clock. And then we have our regular afternoon iPad session at 1:30. On Tuesday, we have the lunch club at 12 o'clock. And then our special guest for this week is the DC Fire Department. So they're going to be talking about fire safety and prevention education. So that's going to be very interesting. This coming Wednesday, I'm doing a training because it is Women's History Month. So I'll be, just like last month, I went over apps by Black developers. I'll be going over apps by female developers. So I'm very much looking forward to that. So please hop on Wednesday at 10:30 and you'll see a lot of great apps. In the afternoon, we're going to have our regular iPad session with DC Public Library as well. On Thursday at 12, we have our lunch hour. And then at 1:30, we have DC Public Library doing a session. Not sure what they're doing yet, but as soon as we know, we'll update the section for the later days of the week. On Friday in the morning, Teresa's going to be talking about hoarding, which is very important as well. And then in the afternoon, we're going to talk about Zoom. So virtual backgrounds, anything about Zoom. At the bottom of each email, we have the library flyer for the next 4 upcoming trainings. So Monday, you get to see the trainings for the whole week. So Monday, Tuesday, Wednesday, and Thursday. So please call the help desk or email the library email to reserve your time slot. Okay, we also have a flyer, this flyer from DC Public Library. If you need help with your taxes, AARP can assist you by making an appointment at the libraries that you see listed. And then at the bottom, just like last month again, we had a Black History Month highlight. We have a Women's History Month highlight. So I chose Ada Lovelace, who was the first computer programmer. So you can read a little bit more about her in here. And you also have all the emails and our help desk number that you can call for assistance. Okay. So again, today we're going to be.
Sorry, you know that Patchwork Library, is it open? Because you know they had a staff.
Yes, they opened this morning.
Yes, they opened this week, so it should be good to go for Thursday.
Oh, okay.
Awesome. So again, for this session, I would say if you please take some paper out, a pen, just to write down some notes. Of course, I'm not an expert on trust. So I have some resources at the end as well from DC that you can call and ask more about this information. But yes, last Friday we went over wills, and today we'll be going over trusts. And hopefully next week during the Monday session, we'll be doing this again. So just keep on the lookout for your email for next week's agenda. Okay?
Yes.
So again, this program is for educational purposes only. It does not take the place of legal advice. You are responsible for going to your lawyer for letting him know or her work with you to manage your legal needs. Okay. So what is a trust? A trust allows you to control how your assets are distributed to your heirs or other beneficiaries. A trust can also help you reduce your tax burden depending on the type of trust you use and how you manage its distributions. Establishing a trust is one of the best ways to plan your estate ahead of time. So again, on the right, what is a trust? A trust is a legal document which provides instructions for handling assets assigned to the trust. So those assets can include checking savings and investment accounts, real estate, family businesses, and insurance policies. And some benefits of a trust includes privacy, avoiding probate, providing funds for your family, and charity as well. So we'll be delving into this. Yes. All right. So again, we're going to examine the function of a trust, discuss the types of trusts, and provide a step-by-step guide to help you set up a trust for yourself and your loved ones. So basically on the right, you can see how a trust functions. So the grantor, you, in your case, would establish the trust and outline how assets will be managed by the trustee, who is basically the trust manager. They manage the trust until its intentions have been fulfilled. And of course, the beneficiary, as you may know, is the person that receives the proceeds from the trust according to the terms set by the grantor. Okay, so again, what is a trust? We're going to go over who should have trust, popular types of trusts, how to choose the right trust for you, the difference between a trust and a will, how to set it up, and some resources. Okay, so again, a trust is a legal contract that ensures your assets are managed according to your wishes during and after your lifetime. Among the many benefits trusts offer are potential tax benefits and the ability to set parameters for how and when your assets will be used and distributed. Okay, so depending on the type of trust, you can act as the primary grantor, the provider of the funds, and the trustee. So you can, again, you can do both. You can be the trust manager as well, or you can enlist a third party to manage the funds on your behalf. Either way, the funds will quickly be distributed based on your instructions at a set time or upon your death. Okay, so some benefits of a trust include avoiding estate taxes, and as long as the trust is not in your immediate control, avoiding some taxes on the income produced by the funds. The biggest advantage of a trust, unlike a last will and testament, is the trust allows you to avoid probate court, like we stated before. So again, on the right, you can see a trust protects the beneficiary wealth from creditors. It allows you to direct your wealth distribution to your heirs. You can avoid probate. You can reduce potential estate tax liability. It provides you tax efficient gifts to charities and providing for needs in case of illness or incapacity. Okay, so for setting up a trust, many people choose to set up a trust during or even before retirement, reducing their tax burden and establishing the foundation of their estate planning. You can also set up a trust that allows you to have access to the funds as needed, but you will likely have a greater tax liability. So there are pros and cons to the type of trust you can get. So who should have a trust? Trust can be extremely useful parts of estate planning, but they may not be relevant or necessary for everyone. You may want to consider a trust if you fall within these categories or have any of the following circumstances. You might be a large estate owner. You might have multiple heirs or beneficiaries. You might have a retired spouse, a desire for financial privacy, or you may have heirs with large debt. So you may want to consider a trust if you fall within any of these categories. Some of these situations are clearer than others. For example, if you have a large estate with multiple heirs and beneficiaries, a trust is one of the best ways to make sure the funds are distributed quickly and correctly once you are gone. The same applies if you have a retired spouse who, without your estate, may only have Social Security income or no consistent income to live on. Okay, may be difficult to understand how a trust can enhance your financial privacy. One benefit of a trust is that in most cases, it does not have to go through the court system to be verified. So your estate and assets will not become a matter of public record. Instead, you can grow your wealth and have it distributed with a much greater degree of privacy and discretion. Also, if you designate a third party as the trustee, so again, the trust manager, you can shield a large portion of your estate from creditors or even the creditors of your heirs. By having the right kind of trust, you can prevent creditors from going after your assets until they have been distributed. So this allows them to grow unencumbered while you or your heirs pay off debt. Again, it offers flexibility. Trusts are very useful because they offer a lot of flexibility for how you or a third party can manage your estate. Each type of trust offers its own unique benefits. So below, or we're about to go through some of the most common types of trust and what they actually do. Okay. So first is the Asset Protections Trust. So as the name implies, an asset protection trust designed to protect your money, specifically from current or future creditors. Essentially, you allow a third party to hold the funds without naming you, the creator of the trust, as a current beneficiary on the account. Once the risk of creditor attack has subsided, you can dissolve the trust or name yourself as a beneficiary. Okay. Tip, it is best to set up an asset protection trust in anticipation of future creditor attacks. If you wait to set it up until after creditors have become the collections process, it could be too late to make any transfers to your trust. So that's a quick tip. We also have the charitable lead trust. So when you create a charitable lead trust, you decide that a certain portion of your assets will go to charity and the remaining assets will go to your beneficiaries. It involves payments either of a fixed amount, an annuity trust, or a percentage of trust principal. So the unit trust to a charity during its term. At the end of the trust term, the remainder can either go back to the donor or to the heirs named by the donor. So you can kind of see an illustration of that on the right. Okay. Next up is the charitable remainder trust. So again, the charitable remainder trust allows you to receive a set income for the duration of your life or until the termination of the trust. In either case, once you are no longer receiving income or the trust has been dissolved, the remaining funds will go to charity. Okay. Next, a constructive trust are not formal trusts created by a trustee, but rather implied trust established via courts based on circumstances. If you have documentation that you intend to leave certain assets or funds to a particular beneficiary, for example, then the courts can decide to grant a constructive trust to carry out your wishes. Again, another tip, you are better off creating your own trust rather than relying on the courts to create one on your behalf, since you have no guarantee that the court will make a decision that reflects your intentions or the best interests of your beneficiary. So basically, you gotta have a part in this if you want to make sure that you, again, all of your wishes are met or are stated in this trust. So just like anything in life, you got to put your head into it so that way you know what's going on, and so you can make your own decisions and create your own future. So next is the irrevocable life insurance trust. So an irrevocable life insurance trust excludes life insurance proceeds from your taxable estate. At the same time, it offers liquidity to the estate and eventually to the beneficiaries of the trust. So an ILIT is one way to include the proceeds from their life insurance policies when they pass away, minus the estate tax bill. It's a type of living trust that's specifically set up to own a life insurance policy, and you can't serve as trustee of the trust. You can name anyone else you like when you form the trust. Okay. Next is a marital trust. This is one of the most common types of trust, specifically designed to leave your estate to a surviving spouse. A marital trust is an IT, that one before, an ILIT, that lets you transfer a deceased spouse's assets to the surviving spouse without incurring any taxes. The trust also protects assets from creditors and future spouses the surviving spouse may encounter. Next is a special needs trust, which allows for beneficiaries to receive government benefits to benefit from the trust without taking away from the current state or federal subsidies. The beneficiary, however, must ensure they do not take distributions that would disqualify them from government help. This recipient will also need to meet certain standards, such as qualifying for Medicare to be considered special needs. and you can learn more about those requirements on the Social Security website. A disadvantage of this trust, the beneficiary lacks control of the funds. The trustee is in charge of the trust, and the person the trust is created to benefit has little say in how their own money is spent. Okay. As spendthrift trust, sometimes beneficiaries have outstanding debts or financial liabilities that can put their future assets at risk. Like an asset protection trust, a spendthrift trust protects your money from your beneficiaries' creditors until the funds are distributed. So again, if you see the image on the right, that's an illustration of how a spendthrift trust works. Okay. Next is a qualified terminable interest property trust, so a QTIP. A qualified terminal interest property trust, or a QTIP, works much like a standard marital trust, except you can choose additional beneficiaries to receive funds upon your spouse's death rather than providing income only to a surviving spouse. So just like a marital trust, but you can add additional beneficiaries if you so choose to. Okay. A disadvantage of this is the beneficiary cannot assign the income or the principal of the trust or the assets as collateral or security for any debt he may incur or to secure a loan for any purpose. In other words, they may not be owned by a trust beneficiary. Another tip, the QTIP is frequently used in the event of a second or third marriage, in which case there may be ex-spouses or children of ex-spouses for whom you would like to leave the remaining funds, which makes sense, okay? A testamentary trust are outlined in wills, ensuring funds go through the standard court process before distribution. That means a testamentary trust will also be subject to court costs, fees, and transfer taxes, and the trust can be subject to court supervision even after the funds have been distributed. So now we're going to go over how to choose the right trust for you. The kind of trust you pick will depend on whom you choose as beneficiaries, when and how you want to distribute funds, and what kind of taxes or potential liabilities you want to protect your estate from. One of the most important factors when choosing a trust is whether you want to access and control the trust during your lifetime. So it is important to distinguish between the two general types of trusts, revocable and irrevocable. So a revocable trust is exactly as its name implies. It can be revoked at any time. Frequently called a living trust, it allows you to access your funds, make changes to your trust, add or take away beneficiaries, or dissolve your trust at your discretion. In most cases, a living trust or revocable trust turns into an irrevocable trust upon your death, assuming you are the grantor. The principal drawbacks of revocable trusts are that they do not necessarily avoid state taxes, and since you can access the funds, they are subject to regular taxation just like any of your other assets. Again, this chart on the right kind of explains it, so I'll go back to it in a second. So an irrevocable trust is set in stone once it is created. You hand over the control of the funds to a third party. It cannot make changes to the terms of the trust after it has been established. It provides far less flexibility, but it is one of the best ways to avoid probate costs, estate taxes, and other financial liabilities, even from the income produced by the trust. Many people who are trying to reduce their tax liabilities or avoid predatory creditors choose irrevocable trusts. Okay, so again, the differences. A revocable trust can be modified after they're created. They can remove and designate new beneficiaries, and they're flexible. An irrevocable trust, nobody can modify it once it's created. It offers tax shelter benefits, and it's rigid. So those are the two differences. Again, typically a revocable trust will allow you to receive all the benefits of the trust assets, the trust income, and the right to use the assets as you choose during your lifetime. Following your death, the trust assets are distributed in the manner you've directed through the terms. It says right here, when to consider if you want to change it, you might have a change in family relations, like a divorce or an illness or a death, a change in your economic situation, or external changes such as changes in the law, moving or buying a new property in a new state, things like that. Again, before we look at the step-by-step guide establishing a trust, it is important to note the differences between a trust and a will. So again, a trust is a fiduciary agreement dictating how your assets will be distributed and managed, particularly regarding how those funds will be distributed to your heirs or beneficiaries. A will can work very similarly, but is often used to create far more requests, including how you want your affairs, both financial and otherwise, to be handled after you're gone. So those are the difference between a trust and a will.
Alex,
So yes,
can you have a trust and a will?
I'm going to answer that at the end because
Okay.
during some of the videos, they might be answered. So I'll
Okay.
keep that in mind, okay?
Mm-hmm.
All right, so again, a will and a trust are both key elements of estate planning, and there is a certain degree of crossover in the powers and effects, but they also have some important differences. A will must be authenticated and verified through a probate court, while a trust usually does not require the involvement of the courts. It can take months or even years for your estate to be distributed through a will, but it may take far less time with a trust. Your time takes effects as soon as it is created, and you can even set stipulations for distributions that occur during your lifetime. A will does not go into effect until after you have passed away. Family members or beneficiaries cannot contest trust, but they can contest wills. That is one of the main reasons wills can take far longer to be authenticated and executed. Okay. So now we're going to go over a quick step-by-step guide on how to set up a trust. So first, you must establish the primary reasons for creating a trust. Do you want to ensure your spouse has quick access to funds when you pass on? Do you have a large family, and do you want to specify exactly who receives a part of your estate? Do you want to avoid certain estate taxes and probate fees? Answering these questions will help you decide whether to choose a revocable or an irrevocable trust, as well as one of the specific kinds of trusts outlined before. If you think you may want to change your trust in the future, then you should choose a revocable trust. You can change it to an irrevocable trust later on if necessary. Okay, next, speak to a lawyer or a financial advisor. You generally do not recommend creating a trust without consulting a legal or a financial professional. You would ideally get advice from both, since they can help you manage various aspects of your trust and financial outlook as a senior, from property allocation to tax mitigation. It is best not to put anything in writing unless you have consulted professionals who can help you avoid potential pitfalls and learn about both state and federal laws that could affect your estate planning. Okay. Next, you write your trust document. This is perhaps the most important step of the process, and it should be done with the help of a lawyer. Your trust document will need to clearly establish the grantor, all of the assets to be transferred to the trust, the beneficiaries, the manager of the trust, and any successor trustees. And then next up is to notarize the trust agreement. So once you have combed through all the details of your trust, you'll need to sign and notarize the document. This will authenticate the document and prevent any risk of confusion or even fraud upon your death. Depending on the state where you live, the signing may require additional witnesses. Yep. And your trust document establishes the existence of your trust, but it does not actually put the financial work into action. You will need to create a special trust bank account and fund it. There may be real property involved, in which case you can simply change the name on the title or deed to the name of the trust. For ongoing contributions to the trust, you can also name the trust as a beneficiary for certain types or sources of income. Okay, some resources for setting up the trust. So it's not too complicated, especially since lawyers and financial advisors can walk through the process. You can check out some of the resources, including Fidelity, which is a long-standing financial institution that can help you set up a trust as quickly as possible. The Federal Deposit Insurance Corporation, FDIC, is a great government resource that can provide you with unbiased financial advice and information related to trust. AARP is specifically designed to help seniors with a wide variety of goals, including retirement and estate planning. And then Mint is a financial application and website that can help manage your assets and connect you with advisors to set up a trust on your behalf. I know in DC, we have the legal counsel for the elderly. So at the end, I'll be putting that number on the screen. And I say that is the best resource to first visit, and then they can either help you there or guide you to the right people regarding your situation. Okay. Again, how much does it cost to create a trust? Costs vary widely, but you should expect to pay anywhere between $1,000 and $3,000 to set up a trust. If you go through a cheaper online service, you may be able to create a trust for just a few $100s, especially if you forego the cost of a lawyer. But again, definitely go through the DC resources to see what's available and to see if it's less expensive. Okay. Can I create my own trust? The short answer is yes, you could create your own trust. You will still need to get it notarized, but you do not technically need a lawyer to make a trust. That said, getting legal or financial advice can help you avoid mistakes and pitfalls, especially if you are unfamiliar with trusts. So unless you are like in the financial industry or really familiar, I would strongly recommend you get that advice so that way they can help guide you in the right direction. Is it worth it to create a trust? If you have property or substantial assets that you would like to pass on to future generations, then it is almost certainly worth it to set up a trust. The cost of making a trust is nothing compared to the assurance that your beneficiaries will receive their distributions quickly and without the need for probate court authorization. If you have relatively few assets or no specific wishes for how your estate should be administered after your death, however, then you probably do not need to bother with a trust. Okay, again, it is advised that you conduct your own investigation as to the accuracy of any information contained herein, as such information, including without limitation, any medical device is provided as is for informational purposes only. So again, consult your lawyer for any assistance with the information that we went over today. But I have two videos that we're gonna watch. Let me look at the time. Yeah, that's fine. And then hopefully this explains some of the questions that you may have. So if someone can let me know if they can
A
hear
lot
it,
of
I'd
people
appreciate
think
it.
trusts are only for the super wealthy. Not true. Trust can benefit
guys hear the
anyone
video?
who wants to manage how
Yes.
they leave their money to their
Okay,
family.
great, thank you.
A trust can give you control over who gets what and when, how they get it, and why. How do trusts work? Trusts are like containers you can put things into. You, the grantor, can place assets like your house, life insurance policies, investments, and other possessions into a trust. These assets become property of the trust and are managed by your trustee. You appoint the trustee to ensure your wishes are carried out. As grantor, you decide who receives the assets inside your trust. Typically, your spouse, your children, grandchildren, and charities of your choice are the beneficiaries who receive the assets held in trust. When you create a trust, you determine how the funds inside your trust will be used and when they will be dispersed. For example, you may want to use assets in your trust to jumpstart your children's careers when they're 25, or supplement their retirement when they turn 60, or pay college tuition expenses for your grandchildren, or provide annual scholarships to your alma mater. Your appointed trustee ensures everything is managed according to your instructions. It's important to know there are different kinds of trusts for different purposes. Some are designed to manage who receives your assets and when. Others may offer tax planning benefits. Make sure you work with financial experts so that your trusts are properly structured to carry out your specific intentions. Trusts can offer you and your family many financial advantages. Talk with your advisor and an estate planning attorney. Find out how trusts can help you create a lasting legacy for those you love the most.
Hi everybody, Attorney Nicole Whipp here with the Family and Aging Law Center. Today I'm going to go over a little bit with you about trusts. I call this Trusts 101, and it's really just an overview about what are trusts and what are they going to do for you, and a little bit about the different types of trusts. The reason I'm doing this is because I know there's a lot of confusion about what trusts really are out there, because I've literally talked to hundreds, if not thousands of people about trusts. I'm not going to get into real specifics about trusts, but I'm just going to give you this overview. So let's get started. So the first question really is, well, what is a trust, right? What is it even? And the legalese of the answer is that it's a contract between the grantor, which is the person that creates the trusts. Like usually if it's your trust, you are the grantor. The trustee, who is the person that manages the trust, it might be you, it could be somebody else, and the beneficiaries, who are the people that are going to benefit from the trust either during your life or after your death. So that's the legalese. What I'll tell you is that a trust is your rule book. Your rule book. Okay, and this is important because if you don't make your rule book, you're going to get the rule book that the state gives you. Okay, you're going to follow the state's rules. And so you can make your own rule book, but you have to create it, and that's what a trust is for. All right, so there's two main types of trusts. And when I say this, what I mean is in the whole world of trusts, there are two very general categories of what trusts are. The first one is what we would consider to be death trusts, also known as testamentary trusts. These are trusts that are created in a will. So the will says, upon my death, this trust is created, okay? But the trust doesn't exist during your life because it's in your will, and your will is a death document. It doesn't come into being, the trust, until after your death. And it doesn't transition control of assets in the event of a disability. So if you're alive and you get sick, this type of trust, a testamentary trust, doesn't enable somebody to take control of your assets in a disability situation. And almost always, it's going to require a probate court proceeding because it's created in a will. A will is inherently a document intended for probate. It's going to require a probate proceeding to create this trust. And that's what's a death trust or a testamentary trust. And so for this reason, a lot of people don't feel that these are very desirable, right? These don't sound like really great things for most of us. So that's why we usually, when we're talking about trusts, are talking about things that are living trusts. And what this means is that a living trust is a trust that exists during your life, okay? Unlike a testamentary trust that doesn't exist until after you're dead. It shifts control in the easiest way possible upon your death or disability, okay? And so unlike the testamentary trust, a living trust does allow the person that you say gets to be the trustee after you to take control of your assets that are in the trust upon your disability or even death. And if you properly fund it, and I'm going to talk about this in a second, a living trust avoids probate, which is really probably the biggest reason why people like trusts, okay? Living trusts come in two categories, revocable and irrevocable. So let's talk about that. Revocable and irrevocable living trusts are definitely two totally different legal strategies, and they accomplish different goals. With revocable living trusts, which is the most common, by the way, when people call me or people talk to me and they say, I already have a trust, 9.9 times out of 10, it's a revocable living trust, okay? We use these almost, I'd say mostly for probate avoidance, right? The main reason people put together a revocable living trust is to avoid probate. And also, I look at a very good reason to have a revocable living trust is so that you can shift control in the easiest way possible when you get sick, or if you get sick, or upon your death. So that's what revocable living trusts, basically two main reasons you'd put one together. They are private if you keep them that way. So we can keep privacy amongst our family or people that we trust. We don't have to go through a court proceeding, which is one of the big things that makes it private. And if you have a properly structured revocable living trust, it can provide asset protection to your loved ones after your death. And this is key, not during your life, after your death. It's important to understand, and this is one of the biggest misconceptions about revocable living trusts out there. Revocable living trusts do not provide asset protection to you during your life. If it's your trust, a revocable living trust is not intended to provide asset protection. And so one of the biggest complaints I hear from people, or people get upset a lot of times, is because they believe that their revocable living trust provides them asset protection. You just need to understand that that is almost entirely not true, and that's not the purpose of it. That's not what it's meant to do. And so don't go around thinking that that's what's happening if in fact you have a revocable living trust. But that's part of the reason why there are these irrevocable or irrevocable living trusts. Once again, we create them while we're alive, but they're mostly used for both tax planning and then asset protection. Generally, irrevocable trusts are really used for very wealthy people because they create a lot of restrictions that a lot of people just don't want to accept. But we can create irrevocable trusts that don't have those restrictions, but I would say generally that's not the way that they're drafted by a lawyer. So they do give asset protection to you during your life and your loved ones after death if they're properly written. We can protect assets from the nursing home, from predators, lawsuits, all kinds of things with irrevocable trusts or types of irrevocable trusts. So it can provide asset protection to you during your life, unlike the revocable living trust. But when we're talking about trusts, it's really, 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 really important to understand that you want to, if you have a trust, you want to use a trust instead of beneficiary designations, okay? This is so common. People will have a trust and they'll have beneficiary designations simultaneously. There generally is not a good reason for this, and it really can cause a lot of problems for you and your family members in the future. Because this is the thing. If you have assets like your 401k, your IRA, and there's beneficiaries on them, your bank accounts, you have transfer on death or payable on death, these are all beneficiary designations. They are not going to pass according to your will or your trust. They're not. They're going to pass according to that beneficiary designation. And so this is confusing to people sometimes because they think, well, my trust says that everything's going to happen the way my trust says, but that's not the way it works when you have beneficiary designation. So it's very important to understand this. And this is a improper way to fund a trust. We don't want to have a beneficiary designation to people. We'd want the trust to be the beneficiary most of the time. So a lot of times what will happen is, people will go to the bank or they'll go to their financial planner and they'll say, well, you're all set. I did your beneficiary designations for you. I just challenge that because that a lot of times is bad advice. You're not necessarily all set because your beneficiary designations are not going to create the same type of plan that your estate plan, whether it's your will or your trust, would do. And so I would challenge that statement. And when you're talking to people at your bank or you're talking to your financial planner, you have to understand they're probably well-meaning, but they're not lawyers, and they're telling you only a very small piece of the story. And the small piece of the story they're not telling you, because they're not lawyers and they don't deal with this stuff, is that they don't explain to you that your beneficiary designations aren't going to protect your assets if your children get divorced, or your children are your beneficiary, gets divorced, gets sued, if they are bad with money, have poor spending habits, if they're in bad money relationships, right, like the wife that goes and spends all the money, or the husband that goes and spends all the money. It's not going to protect your money from those things. If they're have issues with addiction, or they're not able to manage their own affairs because they're sick, right? They need nursing home care, or they're sick, or they have a disability, or they have creditors, or going through bankruptcy, any of those kinds of things. Beneficiary designations do not protect from any of these things. And that's why I'm saying, if somebody tells you that you're all set with your beneficiary designation, well, you're not all set with all of these things. And a lot of times, at least with my clients, they want to be all set with these things. And so that's why you want to have both a properly written and funded trust, because it can protect your money, but you have to have the right kind of trust. And that's also why funding your trust is critically important. So what is funding the trust? Well, funding the trust is the process of moving your assets into your trust. This gets a little confusing for people sometimes. Imagine that you have a bowl and you get fruit in your bowl, right? If you take an orange and it's outside of the bowl and then you put it inside the bowl, is it still an orange? Of course it is, right? I'm not trying to trick you. And so it's just like the way that the trust works. A trust is like the bowl. It's a vessel. The orange is your bank account. You put the bank account inside the bowl or inside your trust, it's still your bank account, just like an orange is still an orange. But you need to get it in there. And that's the thing that most people are not doing, even people that have trusts, is they're not funding their trusts. And so it's really important to understand that if your assets are not held by your trust, the trust isn't worth the paper it's written on. You have an expensive legal document that is not actually doing anything for you. So it's really important. In fact, it's critical to fund your trust. And also understand that when your trust is unfunded, a lot of times what this means is that you're going to end up in probate anyway. So the reason that you set up the trust is not even going to happen. Your trust is going to be empty and it's not going to protect your assets from probate. So unfunded trust is probate. That's a big thumbs down. We don't want that. So this is just a really quick Trust 101. I know I just threw a lot of information at you, but if you have questions, call or come on into my
All right. Well, I hope that was helpful for everyone, especially the videos as well. To answer your question, Anne, that you can have both, but both a will and a living trust, but they do different things. So they have a lot of overlap, but there are also several differences as well. Both are ways to say who will receive your assets, and each have their own advantages and disadvantages. One big difference between the two is in how and when they take effect. Wills don't go into effect until you pass away, whereas a trust is effective immediately upon signing and funding it. It may be easier to think of a will as a simple document. Wills allow you to name guardians for kids and pets, designate where your assets go, and specify final arrangements. While it is an easier process, the simplicity of a will does come with some drawbacks. For example, wills offer somewhat limited control over the distribution of assets. They also most likely have to go through some sort of probate process after you pass away. A trust is a bit more complicated, but can provide some great benefits. Trusts offer greater control over when and how your assets are distributed. They apply to any assets you hold inside the trust, and they come in many different forms and types. Keep in mind that after you create a trust, you also need to fund it by transferring assets to it, making the trust the owner, just like the video just said. This does make trust a little more complex to set up, but note that trusts have one major benefit. They are often used to minimize or avoid probate entirely, which is a huge plus for some people. This alone could more than justify the additional complexity of setting up a trust. So does that answer your question, Anne?
Somewhat. I'm still a little confused, but I know the questions now to ask the lawyer. So
Yes. So
thank you for this. This has really been enlightening.
no problem. So again, I would recommend you start off with the legal counsel for the elderly. So their number is listed right here, everyone, 202-434-2120. The legal counsel for the elderly's hotline legal advice line serves as their intake mechanism for most matters. If you need legal help, please call the hotline/legal advice line. Please do not visit their office without an appointment. So they're open Monday through Friday from 9 to 4:30. They champion the dignity and rights of vulnerable DC seniors 60 and up, providing free legal and social work services to those in need, empowering, defending, and protecting. Attorneys represent seniors facing foreclosures, evictions, and consumer fraud. The legal counsel handles Medicaid and Social Security cases, provides benefits checkups to ensure that seniors and vets are receiving benefits they are due, prepares wills and powers of attorney, and educates elders in ways to avoid Medicare and Medicaid fraud. They also accommodate homebound seniors, providing legal services in their homes. The legal counsel houses the Office of the DC Long-Term Care Ombudsman Program, which advocates on behalf of seniors in nursing homes, assisted living facilities, and those receiving home health care. If you're seeking legal help, please contact the legal hotline at 202-434-2120. Their interpreters is provided as needed. Income guidelines only apply in cases where the counsel provides full legal representation. Your income should be at or below 200% of the poverty level, and assets limit also apply. So again, you must be a DC resident, 16 up, and meet income eligibility requirements. So call that number right here that you see on the screen, and they'll be able to either help you or guide you to the right place. Okay, so does anyone have anything to say? Maybe
AARP
something
number?
they learned, huh?
You said the AARP number?
No,
That's
this
what's
is
on
the
the screen.
legal counsel for the
For
elderly.
the elderly.
So 601 East Street Northwest, their number is right here. So again, these are the services: lawyer
Okay.
services for seniors, low cost attorneys, low cost legal services as well. But does anyone want to share something they learned, something that surprised them? We have a
Well,
couple minutes.
I did have a lot of questions, but I don't know if you know them, Celicia.
Hey, hi there.
Hi, illit, I mean, that one, it was confusing. Testamentary was confusing.
Yes, it's a lot of legal jargon, so I definitely understand. So someone asked, are the videos available? Yes, those videos are available. If you just search like Trust 101 or Basics of Trust, you can watch all the videos on YouTube. But yes, it's I definitely agree with you, Alicia.
So basically, they're really recommending to not just have a will only.
Yeah, so like I said before, they both are similar in some ways, but they're different in the way that they are carried out. So definitely consult your lawyer, but those are some different avenues you could go through depending on your situation.
Okay, thank you. I will definitely call these people.
Yes, no problem. You have a wonderful day. Thank you for your
Thank
question.
you. Thank you.
Mm-hmm. Anything else? Anybody else want to share something they learned, something surprised them?
No.
Oh, I
It's
know.
good information.
I have another question. For example, I'm practically living on my assets. I mean, I had a couple small IRAs and I'm on Medicare, so I mean, the Social Security. So basically, I'm living on them. So how can you transfer them into a trust if you're still using them?
So that's a great question. So from what I got from the presentation, trusts are really used if you have, again, like multiple intended beneficiaries, or if you have like a home, if you have a lot of different kinds of assets, that's when a trust is recommended, because it's a lot of different entities. So that allows you to make it as simple as possible to handle. So When you call them and ask, they'll be able to just say, hey, do you need both or you just need one? Just again, depending on the circumstances is what
Okay,
I got.
thank you so much. Thank you.
No problem. You have a wonderful day.
You too, thank you.
Does anyone know why probate takes a long time?
Cases on the docket sometimes.
Okay.
I said,
Also,
trying to
they-
steal all your money.
Yeah, they said,
Probate takes a considerable amount of time for two main reasons: the necessity of providing all interested persons with due process and the creditor claims period. Other reasons probate can take such a long time can include resolving tax matters, litigation, and finding missing heirs. So there's probably a TV show about something like that. About probate, but those estates with more than 2 or 3 beneficiaries typically take longer to settle through probate because, yeah, if you have more beneficiaries, then it takes longer to follow up with them and get them notified. So those are some reasons why.
And it also depends upon how the will is written.
Yeah, everything they got it. It's a due process. So sometimes they got to take a second because I mean I would rather that than them just saying yes and then the problem later, right?
It should take, if it's written really well, the will is written really well. It should take no longer than a year and a few months because
yeah, that's
because
right.
you
It
have
says
to,
go ahead.
you have to they give you time enough to contact creditors. Once the creditors that period is over, then the creditors cannot, if they don't get in contact within that short amount of time that they give them, then that's gone. They can't attach anything to the estate. Then it's just the time that it takes. It's a set amount of time. But it also depends upon how it's written, and because my dad had an ironclad will. It took me and my brother less than a year. He died in 99, and ours was transferred the beginning of 2000. Yeah. So it also depends, but he had a lawyer do his will, so it was very cut and dry.
Okay.
So it depends upon how well your will is written for probate.
Right. Which is why it's important to consult with the lawyer so that way those kinks can be removed before it goes there. Because once it goes there, yeah, you got to go through the process. So great. Thank you so much. So really quick, I saw basically the difference is a will is strictly concerned with what happens to your assets after you pass away, but doesn't house your assets in the meantime, just like the video. So on the other hand, a trust holds your assets until a predetermined time and provides instructions for how they will be managed and distributed. So wills are subject to probate court. While you may have outlined how you want your assets to be distributed, the decision is still ultimately up to the court. A trust allows you to bypass probate and distribute your assets exactly how you wish. So however, a will provides the opportunity to name a guardian for any minor children or dependents, designate power of attorney, and outline end-of-life wishes. A living trust doesn't afford you these options. So basically, the difference is, can it be active while you're still alive? A will, no. A trust, yes. Do you name a beneficiary? In a will, you do, and in a trust, you do as well. Wills are subject to estate tax, trusts as well, unless it's an irrevocable trust. A will is subject to probate court, a trust typically not. Does a will need to be notarized? Yes. A trust typically not. Does it require witnesses? A will, yes, but a trust typically not. But in a will, again, you can outline your end-of-life wishes, you can name a guardian, And a will is part of public record. A trust, you cannot outline your end of life wishes, you cannot name a guardian, but it is not a public record. So again, there are advantages and disadvantages to each.
That's the best you have to get both.
But yes, if you need a will, if you're married, if you have kids or you own property, a trust is an extra step that can make sense if you have a large or a complicated estate, or you may need more control over how assets are distributed. As mentioned, they can avoid probate, which is public record and can take several months. So just consult your lawyer, see if you need one, if you need the other, if you need both. But hopefully all the information that you saw today was useful.